within 20 seconds.
ओके और इमीडिएटली ना आप लिंक भी शेयर कर देना ग्रुप में।
जैसे आया मैं कर
हाँ जी हाँ जी।
Madam, we are live now.
Okay, okay, thank you.
शेयर कर दिया ग्रुप में।
Thank you, Shashi sir. So, dear participants, welcome all of you in the next session. So, I am sharing my screen. I hope my screen is visible. Shashi sir, is it visible?
Yes, madam.
Yes.
Yes, ma'am. Yes, ma'am.
Okay. So, a very good afternoon to everyone. A most splendid and distinguished afternoon to the esteemed assemblage gathered here. With profound deference and exuberant anticipation, I, Dr. Narendrajit Kaur, in my esteemed role as the in charge of KMV IPR cell and coordinator IPR activities at KMV IIC, extend a heartfelt salutation to each distinguished guests and extend a gracious welcome to the eminent speaker of the day, Dr. T. Pavan Kumar sir, alongside our esteemed principal ma'am, Professor Atima Sharma Dwivedi in her absentia, Dr. Rashmi Sharma, the president of KMV IIC, our revered students and participants spanning the breadth of India and beyond. On behalf of entire KMV family, I welcome you all in this meticulously curated third day of the workshop on intellectual property rights, a testament to our unwavering dedication to intellectual enlightenment and scholarly discourse, and meticulously orchestrated by KMV IPR Cell in collaboration with KMV IIC, marking yet another milestone in our illustrious journey of academic excellence. So I extend warm welcome to Dr. T. Pavan Kumar, esteemed resource person, as he graces us with his expertise in a captivating lecture on the intricate realm of learning on patents. So Dr. Kumar's distinguished insights promise to illuminate our understanding of this pivotal aspect of intellectual property with depth and clarity. So I welcome you, sir, once again to have your session, sir. I welcome you.
Yes, thank
And
you.
over to you, sir. Yes.
Thank you, Dr. Narendrajit. Thank you very much. I hope today we're almost at the last session of this program.
Yes, sir.
First 2 days, we would have learned mainly on different aspects of IPR, focusing on why IP is important for academics and research. In today's session, I'll be dealing with the learning on patents. So I'll take you through a journey wherein I'll be explaining you about the very important aspects related to the patents, and through which you can also get some insights on the structure, the learning aspect, as well as if you wish to file some patents, how to design around it. So this would be the plan for today. Okay. So I'll switch off my video and then I'll share my screen. So Krishnan bolo. Again. Hope the screen is visible.
Yes, sir. It's
Okay.
visible.
So good afternoon, and today I'll be talking to you on learning on patents. So when we talk about patents, I think yesterday I had shown you this slide while discussing on the different types of IPR. For today, to continue the discussion on learning on patents, I just thought we should again begin our session with this slide. A patent, in simple terms, is referred as a contract between the government and the inventor, for which government gives the inventor the right to stop others. That means a patent right is a right given to the inventor through which they can stop others from exploiting their own invention. So it's a conditional grant. It has got balance of rights and obligations. It is also subject to other laws of the land, always granted to the owner of the invention or their assignee. So the meaning of this discussion is a patent confers the right to exclude, but not the right to do. It means, according to the law, the right given to you as an inventor is to exclude others. Whether you wish to perform your invention, whether you wish to commercialize your invention, it is up to you. By law, you get a right to stop others if they are trying to exploit your invention. So therefore, it is also referred as the negative right. And many a times we always feel that the patent practices are the recent practices. Maybe organizations are talking about or the governments are talking about. So therefore, it appears that it is a new practice. But believe me, it is not the new practice at all. The practices are one of the age-old practices which can be referred to the dates of 500 BC. But however, the terminologies that we are using today are new. They are modern. Otherwise, practices are not new. And here is a slide on the patent system timeline. In early 1200s, in Venice, already people were in the practice of providing monopolies. Monopoly in the sense, the patent rights, what we call today. And first recorded patent in England was for glass making device or process, which was granted in the year 1449. So likewise, different parts of the world have witnessed several processes, several procedures, several systems with respect to the practice on IP and especially the patents. If you talk about Indian context, yes, though before 1970 there were several guidelines which are not that systematic, but however, from 1970 onwards, there comes a systematic practice of patent even in our country. And whenever we talk about patents in India, always we refer to the Patent Act 1970 or Indian Patent Act 1970. And the term patent has come from the Latin word literare patentis, which means an open letter. We call it as an open letter because whenever we invent, we disclose this with the patent office. In return to the disclosure, we get the rights. So we are opening about our invention so that we get the rights. So therefore, it is called as a open letter. And to add to the list, to this list, let us look into some historical aspects. The first American patent was issued in the year 1790 for a process of making potash. It is one of the chemical process. Before 1790, there were no patents even in US. And here is the scanned copy of the first patent issued in America in the year 1790. So this is only a half-page write-up. We don't even know what exactly they wrote, but somehow with this document itself is the complete patent document. And if you look into the structure of a patent, I don't know whether you have come across a patent or not. If you have seen a patent document, you would have come across patents with different page numbers, different numbers of pages. There are patents with starting from 2 pages to 200 to 2000 pages. I have seen a patent document at least more than 900 pages. So irrespective of the number of pages, any given patent document can be divided into 4 major parts. The first part is called as bibliographic data. Second one is drawings. Third one is the description. And fourth one is the claims. In the first part, you will find lots of information regarding to the invention that has been filed for the patent, like some numbers related to priority number, application number, patent number, then the dates corresponding to those numbers or those activities, then the names of the inventors, names of the assignee, and some classification codes, which will help you in retrieving the relevant patent information, and citations, abstract, all these. So all this information will be present in the first page of the document. Then comes the drawings. And if it is an engineering drawing, yes, a drawing can go directly. If it is a biology patent, then the sequence of the peptide, sequence of the biomolecules can go there. Or for chemistry people or chemical engineering people, the process, the flow sheet or flow chart can go there. And then the third part of the patent document is described as description. This description is an elaborative part of the patent document. And again, it is subdivided into several fields like field of the invention, background, summary, description of the drawings, and detailed description. And this detailed description part is almost all equivalent to the manuscript that we make for the publication. So that means a patent is a document which is equivalent to the manuscript plus something else. And that something else is all about bibliographic data, drawings, and claims. So the fourth part of the patent is always the claims. You will find the claims at the end of the patent document. Take any country's patent, claims will be appeared only at the end of the patent document. And this claim part will serve as the legal component of the patent document. The first three parts are the technical parts. So therefore, whenever you see a patent, the first three parts are also referred as disclosure or the technical parts, which are very useful for the public. But for you as an inventor, it is the claims part which is more important, because it is through claims you get the rights. It is through claims you get the protection. Whatever is claimed, you will get protection for that. Whatever is not claimed, you will not get any protection. So therefore, one need to be very, very careful while drafting the claims as well as while drafting the patent document. And here is the structure of the front page of the patent. This is this one is from PCT application. This one is from American patent application. As I told you, first page is always referred as bibliographic data, and you can find some names, numbers, dates, diagrams, abstract, references, and all those things. Take any country's patent, you'll find all these kind of information on the very front page. And here is an example of the front page of Indian patent document. And if you have seen a patent filing number for the Indian patent application, it will be having 12 characters. So it starts with the year, then the jurisdiction, then the type of application, followed by a 6-digit common continuous number. Okay, and this pattern of numbering has come into implementation from January 2016 onwards. Before that, there used to be a different pattern, number by jurisdiction by year. And even in the Indian patent structure, you find the application number, patent number, the dates, brand number. So some names, dates, title, all these things will be appearing. One more important thing we all need to realize is, many a times people come to me stating that, Pawan, I am the author of 6 patents. Whenever you say that, whenever you come across someone saying, I am an author of 6 patents, it indicates that they do not have proper understanding on patents. The reason is this. There are certain terminologies which need to be practiced between publications versus patents. If you are practicing publications, the terms like author, manuscript, writing, affiliation goes into practice. But when you are practicing patents, you need to use the terminology like inventor, specification, drafting, and assignee for the respective terms. Because patent is a techno-legal document. So therefore, if you have patents, you have to say that I am the inventor of 2 patents, 3 patents, 5 patents, or 10 patents. I am drafting the specification for a patent. My specification for a patent is ready. I am the assignee, or my institute is the assignee of the patent. So therefore, one need to be very, very careful enough while using the terminologies. From here, I'll take an example of a patent document and I'll show you the different parts. See this is the very front page. I've taken this from an American patent document, and see this. This is a patent number, the date, the title is there, then inventor names are there, assignee or company name is there, application number is there, filing date is there, publication number and dates are there. IPC, International Patent Classification codes are there. Abstract is there. And in case of American patents, they also describe the number of claims and number of drawings on the very front page, along with some references. So this will be a usual practice. In some other countries, they may not put the number of claims on the front page, but otherwise, the practice is almost all similar. And in this, I have marked 3 fields in green, which I feel are more and more important while you conduct patent search and analysis activity. One is country code, the other one is kind code, the third one is International Patent Classification Code. These 3 are very important, and I will be making a detailed discussion of these 3. So then comes the drawings, followed by the description part. So field of the invention is there, the prior art or the background is there, then the detailed description of the drawings, and at the end of the patent, you find the claims. So claims will appear only at the end of the patent document. From here, I'll be taking few more examples of the patents from different countries. I read out the differences between the country name or the kind code or the classification code. See this is GB, Great Britain, this is A, and these are the international classification codes. But in this case, it is PL, Poland, but the kind code is B1. Here it is A, it is B1. And here it is International Patent Classification System. At another example, AU Australia, it is B2 here. And it is EP B1 here. And these are the international classification codes. Similar is here. This is CN China. A is there as the kind code. But this one is Canada. And again A1 as the kind code. And these are the international classification codes. And if you take the example of Indian document, IN is the country code and kind code is A. This is A for this example. And here is the International Patent Classification Code. So take any country's patent. You'll find country code, you'll find a kind code, and also you'll find International Patent Classification System. These 3 are commonly observed characters on the patent document, along with many others. And these 3 have got some special significance because the country code differs from country to country. The kind code differs with respect to the status of the patent application. International classification codes may also differ related to the field of the invention or field of the work to which it is related. So therefore, for us, learning on these 3 aspects will be more beneficial for searching and analysis of patent documents. So therefore, you have come across the kind codes with A, B, right? Whenever you find kind code A along with the patent number, when I say A, it can be A, A1, A2, anything. This is only an application. So if you find any document with A, that is not a patent at all. That is only a patent application or published application. If you find a document with B, when I say B, it can be B, B1, B2, B3, anything. Only that document is referred as patent. It's a granted application. If you find E, it is a reissued patent. If you find D, it is a design patent. Of course, the concept of design patent is not there in India. For any kind of Indian patent documents, you don't find D at all. Only in American practice, quite often you find the documents with D, where they refer to the design patent. Here are examples for the country codes, like US is for United States, D for German, JP for Japan, IN for India. And similarly, all the countries in the world, whichever are practicing patents, they have 2-letter country code for sure. Then comes patent classification. There are majorly 4 kinds of classification systems with respect to the patents. And the first and the most important one, and which is generally applicable for all kinds of patents coming from any country, is International Patent Classification System, IPC, International Patent Classification. Apart from this, American classification is there, European classification is there, and Japanese classification is also there. However, US, Europe, and Japanese classification codes will appear only on the patents with respect to their patent offices, not in all other patents. But International Patent Classification, IPC, will appear on every patent. Then why IPC is required or why it is so important? The reason is all these codes, International Patent Classification codes, are language independent, terminology independent, and they are standardized applications to the documents. Take any document, you will find a IPC. And if patents might be in, you have seen some examples of the patent documents from different countries. All those documents are not in English. Some are in English, some are in their own specific languages. So therefore, these codes will also help you in retrieving the relevant document from a non-English speaking country. So that is the advantage of International Patent Classification System. So broadly, whatever documents are available in the form of patents worldwide, they all are divided into 8 major sections, section A to section H. Each section is dedicated to one field or one wide area. Likewise, section C is dedicated to chemistry and metallurgy. What is the advantage of these codes? Whenever you start searching for patents, you may end up with large number of references. But then reading, understanding, and analyzing and compiling of these large number of patents would be a very, very tough task. So therefore, we need to simplify the process. These IPC class codes will help us in the process of simplification. If you use this code because this International Patent Classification System has got about 12 levels of hierarchy, 12 levels. As you go down from upper to the bottom level of hierarchy, it gets narrowed and the number of search results will also decrease. So therefore, for example, if you use this code while searching, you may end up with 34,000 documents. Out of 34,000, it becomes your duty to analyze them to find out which is relevant and which is not relevant. Analyzing 34,000 documents is not that easy. So therefore, all the intelligence in the person who is performing the patent search lies in identifying a proper International Patent Classification code. If you can further narrow down, you can please do that, and you may end up with 600 documents. Further, if there is a possibility to narrow down, you can still do that, and you may end up with a 98 documents. So see here, analyzing 98 documents appears to be quite easy than analyzing 600 documents. And these two would be much easier than analyzing 34,000 documents. So this is the benefit of International Patent Classification System. And there's another concept called as patent family with respect to the patent practices. A given invention may be filed for patent protection in several countries, including your own country where you reside. So therefore, if you file a patent in India, that is an Indian patent application. Similarly, for the same work, you can also file patents in other countries. Suppose, for example, you filed in India today, later on you also filed in 4 other countries like Japan, China, US, and Europe. So all these 4 which were filed in other 4 countries will be regarded as family members of this original application. So number of applications filed for the same invention at different jurisdictions are referred as family members. And it is not that whatever work you carry out, you can easily or you can definitely get a patent. No. To obtain a patent, your invention or your research work must satisfy the criterias. It must satisfy the criterias. And generally, the criteria of patentability can be referred with NUNS test, NUNS test, novelty, utility, non-obviousness, and statutes of the nation. The first 3 criteria are quite common for any country for filing patents. But when it comes to the 4th one, It is also common, but it may differ from country to country because the Patent Act of each country has got their own guidelines. Depending upon the Patent Act of the respective country, the statutes of the nation, the guidelines given might vary. Otherwise, the first three are very much common. So therefore, here are some list of the inventions which are mentioned in Section 3 and Section 4 of Indian Patent Act 1970. All these listed inventions are not allowed for patents in India. Even if they have novelty, utility, and non-obviousness, in spite of that, they are not allowed because our patent law do not allow these kind of inventions to be accepted for patent protection. Inventions which are frivolous or against the nature, inventions which are about the new forms or property of a known substance, or inventions which are obtained by mixing the two things together, discoveries, mathematical or business methods, presentation of information, discovery of living or non-living things, method of agriculture and horticulture, literary, dramatic, musical or artistic works, or anything that is existing in the nature, any activities which are having only a mental activity but not a experimental possibility, traditional methods, any inventions which are against the public morals or humans or animals or environment, any invention which is an outcome of an arrangement or rearrangement or duplication of the known things, or the method of diagnosis, treatment, surgery, operations, all these kind of inventions are not allowed. Even the inventions related to atomic energy, these inventions are not allowed in India. We need to remember this very carefully. So again, I came back to the slide. The first three parts of the patent document are called as disclosure. The fourth one is called as the claim. And it is the claim which is more and more important for you as an inventor. So now from here, let us make a discussion on more about the patents. See this. Whenever you wish to make a boundary or protection wall for your property, which one do you prefer? 1, 2, 3, 4. Which one do you prefer? First one, second one, third one, fourth one. In my opinion, people will definitely go for 4 because it is more safer than any of these 3. Similar is the case with patents. So whenever you are planning to make a claim, your claim should be like the 4th boundary. Claim should be like this so that no other person can get a chance to venture into your invention. So therefore, a claim is a written statement. Claims are the part of the patent application where the inventor specifically states what their invention is and what it can do. Claims define the legal scope of a patent and define what can be protected by a patent law. And claims define the invention. Here is all about the patent claims. It is the claim or claims which are tested before granting by the examiner. Claims are the legal or exclusive rights. Remember, invention is defined by the claims. So any patent document, if it to be called as a patent, it must have claims. Without claims, a document is not called as a patent at all. Again, to structure the claims, a specific structure need to be followed. So it starts with that. It has got 3 parts: preamble, transition, and the body. Preamble names the invention. Transition acts as a connector word or bridging element. Body means all other elements which recites the limitations, antecedent basis, and all those interrelationships. And if this is your invention, the yellow boundary is the claim. It is the strength of the claim that decides the potential of your invention. If your claim is strong, you have great potential for your invention. If your claims are weak, then your invention do not have any potential for long-term survival. Again, claims are divided into 2 major types. First one is the independent or main claim. The other one is dependent or subclaim. Always the first claim in any patent document would be an independent claim. There can be any number of independent claims in a given patent document, but definitely there should be one at least. I'll take one example to define you how the claim is constructed by taking the example of my own patent for the process of preparation of nicotine. See here is the process, chemical process, and this is the front page of the patent document or the patent which has been granted for us. And if you look into the claims part, a process for preparation of racemic nicotine. This is the introduction of the invention. So that is referred as preamble. Comprising is the connector word and different steps. Step 1, step 2, step 3, likewise, they are all mentioned. So all these elements which are mentioned in the patent claim are called as the body. So therefore, any patent claim should have 3 parts. It should start with the preamble, then the connector, then the body. Connector, the function of the connector term is to connect preamble with the body or to connect body with the preamble. And further, claim number 2, 3, 4 can go likewise, and any of these can be independent or even the dependent claims. So the process as claimed in claim 1, wherein the alcoholic solvent is selected from the group consisting of ethyl alcohol and methyl alcohol. So always dependent claims are those claims which refer to a existing claim or earlier claim. And here are the list of claims that are possible. If you develop a product, it can be any kind of product, chemical product, engineering product, medical product, biological product, whatever it may be. If you develop a product, the patent is called as product patent and the claims are called as product claims. Process claims. And for chemistry people, there is something called as Marcus claim. Marcus structure is a generic structure through which large number of specific structures can be referred. See this example. On this, chloro, cyano, CH2NH2, CH3, CH2, CH3 are there, ethyl are there. But when I file a patent for this structure, I replace methyl, ethyl, and other specific groups with some generic groups. These generic groups will include these specifics along with some other groups, other related groups. So this structure is referred as Marcus structure, and a similar structure can be protected under Marcus claim. This is a great advantage in patent practices for the chemistry people. And there are claims which are referred as Jepson claims, wherein whenever you make an invention about the improvement of the existing products or existing inventions, such claims are called as Jepson claims. So Jepson claims in simple terms can be regarded as improvement claims. And there are another type of claims called as Swiss claims. Swiss claims are nothing but the claims which are for second and further medical use of a compound. Such claims are called as Swiss claims. And here is the list of claims that are allowed in India. As I told you, every country has got their own patent laws, patent acts, and accordingly, their practices will follow. Coming to the Indian context, our practice is the Indian Patent Act 1970, and according to Indian Patent Act 1970, there are some inventions which are not allowed for filing patents. So therefore, here is the list. Product claims, process claims, and composition claims. These 3 are allowed in India. Method of treatment not allowed. New physical forms with enhanced efficacy is allowed, but just new physical forms are not allowed. Living organisms are not allowed except for the microorganisms. And then here is a double funnel approach for the patent drafting. Please see the description present there and try to understand. The wider opening of the funnel is regarded as the invention or the background of the work that we are looking into. Once you develop the work, you need to protect the work through the patent, and wherein your protection is majorly because of the claims that you draft. So the inner opening of the funnel is regarded as claims. That means a believed area where art permits and claims that will be allowed. The objective of any patent document should be whatever claims you write or you draft, they should be granted as such. But in practical sense, many times this may not happen, but in general, you should be confident enough that whatever claim you put in, that might get accepted. And the tip or the outlet of this funnel is regarded as embodiment. Embodiments are nothing but the actual experimentations or the examples that you have carried out for sake of claiming this invention. So this is called as double funnel approach. Now, three terminologies have come here. And not only here, whenever we talk about patents, whenever we discuss about patent practices, generally the patenting activity revolves around these three major terms. One is invention, the other one is embodiment, the third one is the claims. Invention is a broader perspective of your thought process. Embodiment is a specific example which has been created out of your thought process to prove the invention. Claims are something through which you get the protection for your invention. But however, a claim must definitely include at least one embodiment, and preferably a best claim is the one which covers the invention at large. Hope you understood, but otherwise, let us understand these three terminologies with more details in this slide. Invention is a mental construct inside the mind of the inventor with no physical substance. Today, you got an idea of developing something or a flying machine. You got an idea of developing a flying machine. That may be your invention because it is only there in your thought process. But how do you prove it? Unless and otherwise you do experimentation and make a prototype, you cannot prove it. Okay. So making the first prototype or making at least one prototype may be regarded as an embodiment. So therefore, an embodiment of the invention is a physical form of the invention. Then now, what are claims? The claims protect at least one embodiment, but the best claims protect the invention. That means the inventor's embodiment and all other possible embodiments of the invention. So for example, your invention is all about making a flying machine. That is only a mental construct inside your mind. Once you start experimentation and make a prototype of the flying machine, that will become an embodiment. So what is your embodiment here? A flying machine with so and so size, with so and so design, with so and so color, and with so and so functionality. But is that the only possibility to add to your invention? The answer is no. You can make several such kind of examples to satisfy the invention. So therefore, whenever you go for claims, your claim must at least protect one embodiment. Preferably, you should claim in a manner that your claim can protect as many number of embodiments as possible. So that is called as claim or claim protection. And as I told you in the double funnel approach, invention is a very broader perspective. Embodiment is a very specific form of experimentation to prove your invention. Claims are between the invention perspective and the embodiments. So therefore, a claim is the one which protects the actual experimentation and also the possible predictions or possible experiments which you may predict. Now, To explain this further by taking an example, I thought I should definitely show these 3 or 4 slides. So here is the invention, which is a mental construct in your mind with no physical presence. But when you put your thought process into practice, you may come up with an example, experimental example. So that is called as embodiment. So this is your actual experimentation. But whenever you put a claim for your invention, it should have a broader coverage about your around your embodiments. This claim scope may not be as wide, as broader as that of your invention, but it should be as broader as possible to cover large number of embodiments. So then, for example, if your invention is all about making first cup to have a handle, just imagine there is no cup available in the market which is having a handle. So a cup with handle is not available in the market. If you are the first person who could get an idea of making a first cup with handle, the invention is first cup to have a handle is the invention. But whenever you get an idea, immediately you cannot show a product. You need to put your idea into practice to make some products. To put this idea into practice, you have made a product of red clay cup with handle. The invention is first cup to have a handle, but the embodiment is red clay cup with handle. So what are the specific parts here? One is clay, one is red. Cup is common, but you have made a red clay cup with handle. Is this the only possibility to prove your invention? The answer is no. The cup can be blue, white, yellow. Material can be clay, glass, plastic, many others. So you can keep on doing so many. But again, there are many other possibilities also. So therefore, in order to file a patent application for this specific invention, you have to claim in a manner that along with the red cup, it also covers all other possible cups. See here, invention is all about first cup to have a handle. And you have made only one example of red clay cup with handle. But whenever you go for patent protection, you construct a claim in this manner. A cup with a handle. A cup with a handle is the claim. So a cup can be a red cup, a blue cup, a white cup. A cup can be with clay or many other material. So the clay or the color may come in further claims like claim number 2, 3, 4, and 5. But always the first claim should cover as many number of embodiments as possible. Why this is required? Narrowest scope is very much required. At least doing one example is very, very important to prove the validity, to satisfy the validity of your invention. And broader coverage, though you made only red cup, but through claim, you are covering more than one. Not only red, many others also are covered through your claim, because the broadest scope is very, very useful for commercial protection. So that is how a claim scope need to be defined very properly. See, this would be the scenario. A cup with a handle. Though you made only red cup, you are claiming in a fashion that a cup with a handle. Whenever you say a cup with a handle, blue cup, white cup, all kinds of cups are covered here. So tomorrow, if someone gets an idea of having this kind of cups, by looking at your patent, they cannot do anything, because already you have protected a similar kind of invention through a broader coverage. Even in case of chemistry examples, I'm showing you one of our own example here. We have developed around 30 analogs of indole sulfamyl N-hydroxybenzamide derivatives, and we screened them for HDAC inhibition. Luckily, 2 of these compounds were showing very good activities towards selective HDAC inhibition. And we thought of filing patents. Though we made only 30 compounds, if you see our document, we have put a marker structure, which is a generic structure with this kind of pattern. See, this is the marker structure that we kept in our patent document. These are the 30 compounds, 25 or 30 compounds, but this is the generic structure. Here, this aromatic ring is replaced as ring A, and this part is replaced as ring B. So this ring A and ring B can be any kind of aromatic rings, and many other specific functionalities are referred as generalized functionalities like R1, R2, R3. Though we made 30 compounds, but by looking at marker structure, some thousands of compounds can be protected. So this is a allowed practice in patents. So now you all might have understood that the game is all about the claim. It is the claim game. Whenever you talk about patent, the most important factor in patenting activity is the claim. If you are perfect in drafting the claims, then your patent is very, very strong. You are very, very safe. So now let us understand more about the claims concept by taking an example of this, as I am showing on the screen. So when I ask you to define this invention, suppose if this is our invention, how do you define this? People may call half-filled glass. Some others may call half-filled or half-empty glass. Glass is half full. That half means 50%. Glass is half empty. So whenever you say this part is remaining, someone others can also look into this. And whenever you say this you are keeping for others to venture in. So therefore, or if you want to cover both, you may do this, half full and half empty. But are these the only possibilities with respect to the protection of this invention? Are these the only possibilities? Many of you may feel that yes, these are the only possibilities. Either it is half full or half empty or both, right? But if you ask me as a patent specialist, my answer would be not any of these three. Whenever you say half full or half empty or both, then what about these? Anyone coming up with these kind of experimentations will definitely find scope to obtain patents, because maybe you are the first person to come with an invention, but by looking at your invention, they can find more scope to venture in and to come up with the better versions or different versions of your invention. So therefore, to avoid all these kind of complexities or all these kind of possibilities for giving scope to others, it is always suggestible to draft a proper claim. So now my answer would be this: liquid water bisecting an open cylindrical vessel. So now you tell me whether it is 50% or half fill or half empty, more than 50%, less than 50%, 70, 80%, 90%, any percentage, everything is covered. So it divides the glass into two parts. What is the percentage of the two parts? It may differ. It may vary. So this is how one need to be very, very efficient in drafting the claims. These are some points which are very, very important to be addressed while drafting the patent document. One need to understand the complete invention, and one has to make a complete gist of the inventions, and you should use or find right embodiments. Always one should try to find the right words or terminologies, because words are power. Whatever terminology that you use for drafting patents, they have great significance and great impact for protecting your invention. And you should also have imagination on how competitors could avoid the claimed invention but still take advantage of its teachings. So all these things need to be addressed very properly while constructing the claims or drafting the patent. And these are some of the terminologies that one need to avoid while making the patent document, especially while drafting the claims. laudatory terms, limiting terms, comparative terms, indefinite terms, units of measurement not in metric system, approximate terminologies, all these need to be avoided. Now let us take one more example. Maybe you can put some efforts in drafting the claim, because by now we all know that a claim has a specific structure through which one need to construct, and accordingly, even if we make only one or two examples, but while claiming, we can go for wider coverage. So with these two aspects in mind, so let us take one more example as an hands-on exercise. Take the example of cheeseburger. If this is our invention for which we are seeking protection, then how do you construct the claim? How do you protect it? Please look at this cheeseburger. Now try to recollect the claim structure. Claim has three parts: preamble, transition, and the body. Preamble generally introduces the invention. Transition is like a connector word, and body will recite different elements of the invention. So now this is our invention, and try to construct a claim. You can please put your answers in the chat box. I am giving about 2 to 3 minutes. So you can take 2 to 3 minutes and come up with a claim for protecting this particular example. We'll be very happy if there are some efforts from the people on the construction of claims.
Dear participants, you can write your answers in the Zoom chat. And if you are watching on the YouTube, write there your answers, please.
Yes, please.
I think so. They don't know the answer.
Okay. So then fine. Now, if you look at the example, there are two buns and a cheese and a beef patty. This is what is mentioned here. And if this is our invention, how do we really come up with a claim? The answer is here. A cheeseburger for consumption is the preamble, which is introducing the invention. Comprising is a transition or connector word. And coming to the body, first and second buns, a patty positioned between said first and second buns, and a slice of cheese melted on said patty. Nowhere I am using the beef, the term beef, because once I use the beef, it becomes so specific. So if I use beef there, someone who has made a patty without beef and with other material, any other material apart from beef, can also get patent, can also get chance to file a patent. Or even if they don't file a patent, they can get a chance to practice on their own. And you may lose the priority or you may lose the commercial factor for your invention. So therefore, your claim must talk about the invention. It should also have a broader coverage. So what I do in the second claim, I now mention about the beef patty. The cheeseburger of claim 1, wherein the said patty is made of ground beef. So I'm introducing some specific factors in the dependent claims from claim number 2, 3, 4, or 5. So likewise, one has to learn the art of patent writing or patent drafting. Now, you may also get a doubt. The earlier example was with 2 buns. What about if someone comes with 3 buns or 4 buns or maybe 50 buns? Whether you have 2 buns or 50 buns or 1000 buns, that claim is valid, because it says first and second buns and a patty position between the said first and second bun. So therefore, whenever it is with 2 or more than 2, whenever you say first bun, This, if this is first, this one is second. If this is first, this is second, or this is second. So wherever you start, that will become the first one. The other one would become the second one. So there is a possibility of only first and second ones. The said first and second ones. So that is how one need to develop the art of writing patents. Because technically, we all might be very, very strong. We all might be very, very knowledgeable. But patent is not just the technical document. It is a techno-legal document, and one need to integrate these two parts of the document to make it as more and more effective. And always remember, the first draft while practicing patents need not be perfect, but it needs to be written at the earliest. So whatever goes into your mind, please put it into the document and call it as a first document or first draft. And once you make the first draft, you can start fine-tuning that. Because even now, I still remember some of my colleagues from last 4 years, whenever they see me on the corridor or here and there, they realize that they have to file patents. Since last 4 years, I am listening the same words. पवन जी, हमारा 2-3 पेटेंट्स है, हम आपके पास आएंगे डॉक्यूमेंट लेके. 4 years over, they have not come. Even today, tomorrow, whenever they see me, they tell the same thing. The reason is somehow they are struggling to make the draft. Why they are struggling? Whatever draft they are planning to make, they wish to make it in a perfect manner. So first draft need not be a perfect draft. Don't go for perfection for the very first draft itself. First draft is a very rough draft. You just put the title, whatever information you have, whatever knowledge you have, whatever material you have, you can dump in there and call it as first draft. And from there, you can start fine-tuning. If you don't make that, and if you take more and more time in making first draft, you are not on the right track. This is a practical difficulty that I am seeing in most of the academic and research sectors. So therefore, of course, for all of us, it appears that research is to see what everybody else has seen and to think what nobody else has thought. But invention is not like that. Ideas might be common. Invention are not that common. Invention are rare. We need to contribute to the rarest part. And if you always do what you always did, you will always get what you always got. So therefore, this has been our regular practice. We need to come out of this routine practice and we need to really look into the practice of making patents. And one more important thing is, many a times people feel that patents can be possible only for the works which are 100% new. The answer is no. Even if you improve the existing patents, and if that improvement is a significant improvement, you can get patents. 90% of the patents worldwide are filed for the improvements rather than 100% original works. Okay, so therefore, take some patent as reference, read it thoroughly, take some more relevant patents which are similar to the existing example, try to come up with a modification, a significant modification, so that you can get a new patent. And here is the patent filing process. The day you go to the patent office and file your application is called as filing date or priority date. Within 18 months, it will be published. And in about 24 months, it need to be granted. But however, in practical sense, it may take around 3 to 4 years in India. In some countries, it may take about 2 to 3 years. And if your patent gets granted, it will be valid for 20 years from the date of filing. So this is the timeline of activities, and patents are valid for 20 years from provided if they are granted. And if they are granted, that validity will be 20 years from the date of filing, not from here, but from here. So the entire time duration will be 20 years. Only the granted patents will be having validity. If your patent is not granted, it has no significance at all. And here is the flow chart showing you the different steps involved in the patent filing activity. The day you go to the patent office and file your application is called as the filing date. There is a possibility of filing a provisional application also. And once you file provisional, within 12 months, you need to convert it into complete. And from the date of first filing, within 18 months, it will be published. That is called as pre-grant publication. And the fees, here is the fees for filing patent application. And individual, startup, and academic institute, the fees is 1760, 8,800 for the institutes like us, CSR or other companies. This is a offline fee. If you go for online filing, again, this fee would be reduced by 10%. And if you don't want to wait for 18 months to get your patent to be published in Patent Office Gazette, you can opt for early publication by paying little more fee, so that this 18 months can be reduced to only 2 to 3 months. As an inventor, it is your duty to request the patent office for examination. So earlier, 48 months were there for the inventor to file a request for examination. But according to the recent amendments, there were recent amendments, patent amendments. According to the recent amendments, this 48 months has been reduced to 31 months. Now, inventor or the applicant will get only 31 months to make a request for examination. Once you request by paying the fees, then only your patent application will be examined. After examination, patent office will give you the first examination report. If first examination report has no objections, then your patent will be granted. If you face any objections in the first examination report, you need to reply to that within about 6 months. And again, it will be re-examined. After that, if it is found suitable, your patent will be granted. Otherwise, it may be rejected. Meanwhile, you can also opt for the process of hearing. So all these processes will be there. Proceeding, all these are possible. And here is the amount, the application fees and other kinds of fees associated with the patent practice. Individual, startup, and academic institute will go under natural person category. All others will come under this category. Earlier, there used to be small entity, but now it is not there. There are only two categories. One is natural person or startup or academic institute. The third one is others. For us at CSR, this is the filing fees 8,000, but for you it is about 1,600. And each patent document with the filing fees of 1,600 or 8,000 can only include 30 pages and 10 claims. This is the standard document. If there are more than 30 pages and if there are more than 10 claims, for each claim and for each page, there is an additional charge of this much. And request for examination is 4,000 with respect to startups, individuals, and academic institutes. But for others, it is 20,000. And here are the renewal fees one need to pay towards the maintenance of the patent, provided if it gets granted. So the regular fees that you pay while filing will also include 2 years of maintenance. And renewal fee from the year number 3 will be need to be paid, provided if your patent gets granted. So if your patent gets granted, you will also need to pay the renewal fees. For 3 to 6 years, it will be 8,000 for you and 4,000 for others. For 7 to 10 years, around 2,400. For 11 to 15 years, around 4,800. For last 5 years, it will be around 8,000. So as the duration of the patent or as the lifetime of the patent is increasing, the cost towards maintenance also will increase. Suppose if you do not find any commercial benefit of your patented invention and you are paying the renewal fees up to 10 years, but now it appears to be more burdenous. So in that case, you can just stop paying. Whenever you feel that your patent may not attract any commercial benefit, you can just stop paying the maintenance fee. That's all. So it goes into open domain. Now, no harm will happen to you. And apart from filing patents in India, you can also file patents for the same works in other countries, like I had shown you. For some of our inventions, we filed patents in more than 7-8 countries. So for For filing patents in foreign countries, there are two possible ways. One is Paris Convention route. File in India today, you will get 12 months time period to file in those respective countries. This kind of practice is called as convention application. And in all the interested countries, you need to make an individual application by paying the fees. There is also another route which is called as PCT application. File in India today, within 12 months, make a PCT application, which is also referred as international patent application. And after 12 months, you'll be getting another 18 months time period to decide in which countries you really wish to enter. After 30 months, it is your duty to enter into different countries wherever you wish, along with the respective filing fees, so that your patent application can be filed. So meanwhile, there are several other options, which are other services which are possible and can be taken by making some fees. Now, many a times you might come across people referring as global patent. I have a global patent, or I have a world patent, or I have an international patent. You might have come across these terminologies. Yes, and I don't know whether you believe that these three are there, or believe that these three are there, or you don't believe that these three are there. I don't know, but the reality is only one. There is nothing like global patent or world patent or international patent. If someone comes to you and tells that I have international patent, I have global patent, or I have a world patent, that means wrong. There is nothing like global patent, world patent, or international patent. But yes, there is something which is only international patent application. So there is only international patent application, but not the international patent, not even the world patent, not even the global patent. And then now you may get a doubt. Suppose if you have a patent at US or at Germany or at Europe, then how do you refer them? You need to refer them as abroad applications or foreign patents or abroad patent, not the international, because patent rights are territorial in nature. And this is our regular practice. We know many things and we develop feeling towards few things, and we hardly do very few of them. Right? So knowing, feeling, and doing. We know many, we get attached to few, and we hardly does very few out of those. But now doing part need to be increased. As long as we start doing many things, that will really fetch us a productive and prosperous intellectual property. How do we practice this? Again, it is directly correlated with our research practice. Formulate hypothesis, accumulate data, do extensive testing. Is this the kind of research that you are doing? We need to question ourselves, and also we also need to answer by our own. If the answer is yes, this is the old way. But then what is the new way? Formulate a hypothesis, patent it, raise some million. So whatever research work we carry out, they need to be translated to the higher versions, and wherever there is a possibility, we should take them for IP protection. And through this, probably we can exploit them for commercial benefits. So this should be the strategy for research these days. And this is the new way which has been already adopted, implemented, and has been practiced, or is being practiced very systematically by the countries whom we refer as superpowers. Go to US, go to Japan, go to Korea, go to Europe. Their strategy towards R&D is this. They do research, they take their research to the higher levels, and they translate it, and they make it as a technology, and they get the profits. They make the profits out of their research. So this is the new trend which need to be practiced. Why? The reason is very simple. future wars will not be fought over territories, but over ownership and exploitation of ideas. This, I think, yesterday also we have discussed. So therefore, before I conclude the session, once again, I wish to wish to make you realize that though our research practice has been mainly towards making scientific publications, now the time has come for us. We need to really relook into ourselves to reorient towards making India first, innovation first, and IP first. So IP plays a very, very important role in the nation development. So with this, I just stop here. Thank you. Thank you all. And if there are any queries, we can take that. We can take.
Yes, sir. Thank you so much, sir, for such an enlightening session. So, dear participants, if you have any questions or any query, you can raise your hand or write in the Zoom chat. We will take your queries. We will take the queries from the YouTube link also.
Yes, yes.
I think today no queries are there. So, dear participants, if you have any query, just write in the Zoom chat, or you want to know and want to have any knowledge regarding IPR or filing, etc., you can do that also. Yes, Dr. R. Kanak Sudha. Shashi sir, please unmute her.
ट्राई करिए सर, हो जाएगा आपका.
Okay, Dr. Kanak Sudha, please try to unmute yourself. Or raise your hand. Yeah, she is there. Yes, ma'am.
Thank you very much for the very informative session. I have a couple of queries. You stated that traditional methods cannot be patented.
Yes.
Right? If that being the case, how is that many of the agricultural products of India, right from neem to turmeric to very many crops and other spices, are patented or trying to be patented by foreigners? How is that possible?
See, actually, this concept has come after the experience of Haldi and Neem case studies. Okay, what happened is in India, we all know Haldi and Neem are traditional practices. Everyone knows their benefits. But there were patents which were filed for Haldi in US. Those not only for Haldi, even for Neem also. Haldi case study was from US. American Patent Office granted patents for the use of Haldi. Okay. When it came to the notice of Indian government, so this case was fought by CSIR.
Yeah.
Okay. So CSIR stating that use of Haldi is a very age-old practice in India. And American court needs a written evidence of any of the existing practice. Unfortunately, there was no written evidence found in Indian territory on the use of Haldi. But later on, we could find a written evidence from one of the Persian document, because Persia is one of the countries which invaded India. So by producing that document, we could finally win the case. Similar is the case with Neem. And there they stated that any kind of traditional property is already into the public use. So therefore, no IPs can be granted on traditional property as such. But however, if you bring any significant improvement, or if you make a value addition to the traditional property, and if that value addition or the improvement that you make, if it satisfies the patentability criteria, then there are chances of obtaining patents.
Yeah, my question number 2 is, you said that a product or some intangible things can be patented. Now, suppose you patent one product. Let us assume that we patent a product. You make an improvement. You are getting a patent, but then down the lane you are improving that product. Should that product be given for repatent, or will it be clubbed with the original patent?
See, again, there are two possibilities here. You have made a product, a patent is already there.
Yes.
Then you are improving the existing product to make it much better.
Yes.
If your improvement is a very significant improvement, there's a possibility for you to get a new patent.
So I need to reapply.
There is a possibility. You can reapply. You can apply for a fresh patent. You can apply for a new patent. That is
Okay.
one possibility.
Okay.
There's another possibility. If you feel that whatever improvement you made may not be a very may not be entirely new thing, but for you it would be better if it is added to the existing patent.
Okay.
In that case, you can file a patent of addition. You can make a patent of addition so that this new part can be added to the existing one. And whenever existing patent expires, this new part is also will also get expired. So both possibilities are there.
Thank you, sir. Thank you very much.
Thank you, ma'am. Thank you for your question. Yes, anybody else from the participant? If they want to say, ask any question, or they want to give feedback for this workshop, 3 days workshop. So we welcome you all. So if you want to say anything, we'll take your feedback also. Any participant or any student from our college?
I think people are feedback in the chat box. Okay.
Yes, sir. They are writing in the chat box only. Thank you, organizers, for wonderful program. Learned a lot about patents and its filing. Thank you so much, Aditi Acharya ji. Thank you so much. So let's see if any queries are there. Hanji sir, one query is there by Amreen Makbul. So you mentioned about some of the non-patentable inventions in India. I did not get the reason behind it.
Okay. See, every country has got their own patent act or patent laws. Accordingly, Indian patent practices are governed by Indian Patent Act 1970. So according to Indian Patent Act 1970, there are two sections, namely Section 3 and Section 4. The inventions which are listed in these two sections are not allowed for granting patents in India. The reason being, there are several reasons, because every country has to make progress by keeping the benefits or the merits of their socio-economic and other factors. And India considers inventions related to the listed ones in Section 3 and Section 4 are not really that helpful in progressing as a nation at large. Maybe that would be the reason. Otherwise, as such, why they are not patentable, there is no any justification to my knowledge, but it is a law which says these kind of inventions are not allowed. Because see, one example I will cite you, pencil with eraser. Pencil is there, eraser is there, both are known. According to Indian Patent Act, if you make a pencil with a pencil and if you club pencil and eraser together, it appears to be new thing, but there is no innovativeness. The same thing is patentable in US, but not in India, because our Indian Patent Act says any invention which is a result of combination or aggregation of two factors, wherein this aggregation do not yield into a new result. So likewise, they have summarized what kind of inventions are not allowed to be patentable. Okay, this is the reason as far as I know.
Yes, sir. Thank you, sir. And sir, I just want to share with you and all the participants over there that our institution is achieved with 35 IPRs, including copyrights, patents, national, international, and design patents also. and we have also filed many are in the pipeline, and including me, I have published one patent, and 3 copyrights are granted, and 1 is filed, sir.
Oh, very
So
good. Very good.
thank you so much for your
Really
guidance.
appreciate. Really appreciate. Convey my
And
regards to all the team and also your principal, madam.
yes, sir. Yes,
Your
sir.
body
Yes,
is
sir.
very
She
good.
is the motivation and inspiration for all of us, sir. And sir, our fashion designing department is doing a lot. They have,
Last week we
I think,
discussed, right?
yes, sir. Yes, sir. Dr. Harpreet Kaur, she's also in charge of KMV IPR cell, but she's on leave.
Okay,
So
okay.
that's why she's not there in the workshop. So she goes, I mean, the whole credit goes to her because she's the first one to
This
file all the
is correct.
copyrights and started this thing. And we people all just followed her.
No,
Yes,
really, see, we need someone to make the initiative. So once someone initiates, then slowly it will be taken forward.
yes,
Correcting
yes.
numbers from a college is not a simple thing. I really appreciate and hope these numbers should improve further year after
Yes, sir.
year, and we should make a.
And so many are filed, so will be granted in some
Yes,
days.
yes. Anyway, granting
Yes,
is a time-taking activity. We need not worry about the
yes,
granting process. It will be in the flow. Okay.
yes, yes,
So
I
good.
have just
Really
one
appreciate.
last query, please.
Yes,
yes,
ma'am,
yes,
yes.
Sorry
ma'am.
for the
Yes,
interruption. I had given it in the chat box as well.
Yes.
There are certain, due to certain technological advancements, certain processes they become very soon they become obsolete. So that being the case, something which is being patented and gets obsolete, can that be claiming that it is an obsolete one? Can that patent be challenged?
See, like if the patent term is over, so I
Now,
think then
before it gets over,
before
before it gets over, somebody else is challenging and claiming that it's an obsolete one.
yes, yes. See, a patent can be challenged. See, if you come across any patent and then you feel that no, this patent, whatever patent is granted, this process or technology need to be, it won't appear to be really new. It is already there sometime back, maybe about 20 years back or 30 years back, or it is already into practice. So then in that case, you can always challenge it. Yes, there's a possibility of challenging and there's a possibility of infringement also. You can also say that you are infringing the existing product or existing patent. That is all. That is always there, and there are several such kind of examples where these kind of challenges have been taken to the court, and people who challenge could win. Yes, it's possible because it is a techno-legal activity. So whatever legal possibilities are there with respect to property protection, like traditional property protection, similar kind of practices are allowed for IP. It is there.
yes, sir. And one question is on the YouTube chat by Mr. Varun B. He was very aggressive there. If 2 persons combine to create a plan and end up in dispute, whom will the patent favor?
See, whoever files first, it goes with the concept of first to file.
Yes, sir.
Whoever files first, it will go to them.
Yes, sir. I hope Mr. Varun B, you have got your answer.
Yes. And
Right.
in case of American practices, earlier they used to have a practice of whoever invent first, they used to get, irrespective of whoever files first. But
Yes.
later on, US also adopted the same strategy of first to file. So now everywhere it is first to file concept.
Yes, yes.
Yes.
So thank you, sir. I think no more queries are there. Let me check on the YouTube chat once again, if any question is there.
Might be slightly weird, but suppose if the partners they file together, but after filing, if they have a split and if they are going legally.
No, pardon, please repeat.
While filing the patent, they go together.
Okay.
But then after filing, due to certain factors, they are splitting and they are going legally.
See, whenever they are filing,
shouldn't invention come here first?
no, I'll tell you. When they are filing together, in the sense, there will be a single patent application with 2 names you are talking about, right?
Yes, yes.
Single patent application, 2 names are there, they have filed it. After that, if they fight on their own, that is their problem, because patent will be on both the names. Okay. Suppose, for example, again, there are several factors. if these two people are also the applicants, then the legal battle comes into the place. For example, if we both are working at one institute, we filed a patent. The patent ownership goes to the institute. Okay, so in that case, 2 or 3 people doesn't matter whether they fight or they are together. But if we both are the applicants and later on we start fighting, there'll be 50-50. The rights will be 50 for you, 50 for me. And based on that, we need to sort them out.
Okay.
Okay.
Yes, sir. Thank you so much, sir. So we have taken, I think, almost all the queries. So let me have a formal vote of thanks, sir. So on behalf of my whole KMV family and KMV IPR cell, I extend a heartfelt thanks to you, sir, for gracing us with your profound knowledge and insights during this enlightening session on learning on patents. Sir, your expertise in the field of patents has left us enriched and inspired, and your detailed explanations and real world examples have provided us with a deeper understanding of this complex subject. And we are, sir, grateful for the time and effort you dedicated to preparing and delivering such an informative lecture. And your passion for sharing knowledge is truly commendable and has undoubtedly broadened our perspective, sir. The strategies and tips you shared for navigating the intricacies of patent learning will undoubtedly prove invaluable to all of us in our respective endeavors. Once again, a big thank you to you, sir, for engaging and insightful session. And we look forward to more opportunities to learn from your expertise in the future also, sir. Thank you so much, sir.
Thank you.
And sir, yes, I would like to thank Dr. Kapil Arya, sir, for his lecture on essentials of copyrights, trademarks, and industrial design. It was also very informative lecture, sir. Thank you so much. Thank you, sir.
Thank you very much, and I wish you all the best. And I really appreciate the efforts of Kanya Mahavidyalaya, and I hope your college will definitely do a great progress in the years to come with respect to IP also. Of course, you are doing very good in all other aspects, and IP is also to be taken care to that extent. Wish you all the very best.
And sir, I like to thank my organizing team, KMV IPR cell, and I want Shashi sir to give a spotlight on them also. Miss Navgeet, Mrs. Shikha Vishesh, Dr. Sandeep Saggu, and Dr. Monica Rani. They are always with me for organizing this event a great success.
Oh.
So, and Mr. Baljit from animation department. So thank you each and every one of you. So thank you very much.
Thank you, and wish you all the very best. Thank you.
Yes, sir. Yes.
Very happy to know that there's a good team around that.
Yes, sir. Thank you, sir. And I would like to thank at the last but not the least, our principal ma'am and Dr. Rashmi Sharma, President KMV IIC, and Mr. Shashi. He is a big support as a technical team behind the successful event for this online event. A great success. So thank you each and everyone, and my dear participants, thank you so much. So feedback link and attendance links are shared. So please fill all those forms for getting your certificate. Thank you. Thank you.